Thank you so much for joining us for our first Freeform Friday. We plan to go live, although today we're going to post this after, and make a video at this time every week that will feature Legal Aid of North Carolina attorneys, staff, and other guests discussing legal news or providing information on a broad range of important topics. The video today will discuss North Carolina's new remote notarization law and also stimulus check grabs by creditors. If you have general questions, feel free to leave it in the comments on Facebook and we can try to help. For specific questions, call our helpline at 866-219-5262. I'll post a direct link in the comments, but you can also find resources and videos on our website at legalaidnc.org. Without further ado, I'll turn it over to our senior law project attorneys, Meredith Gregory and Angeleigh Dorsey.
Good morning, everyone. My name is Meredith Gregory. Thank you, Hannah, for that introduction. I am a supervising attorney with the Senior Law Project of Legal Aid of North Carolina. I'm here this morning to talk to you about a few very recent changes to the North Carolina laws that govern the notarization and witnessing of legal documents. And this is a brand new change to the law. These new laws went into effect on May 4th of 2020, so literally 4 days before today. So as some background, lots of legal documents need to be either notarized or witnessed to be valid and enforceable. Some examples of those types of documents are end-of-life planning documents like wills, powers of attorney, that sort of thing. And the North Carolina laws that deal with notarization and witnessing say that when used to say before this change, that when documents are witnessed or notarized, then the person making the document, so the principal, and the notary and witnesses, if they're needed, all have to be in what was called close physical proximity to one another. And that was interpreted to mean that they literally had to be, those people literally had to be physically close to one another in the same room together. And as you can imagine, in this time of COVID-19 and social distancing, all those people being close together in one room together was very concerning and problematic. So in this most recent legislative session, the North Carolina legislature has just passed some new laws that remove this close physical proximity requirement. Now, by these new laws, legal documents can be notarized and witnessed by video conference technology. So that means things like Zoom, Skype, that sort of thing that lets people see one another and interact with one another by video conferencing. Another change to the laws is that for some documents, the witness requirement has actually been completely removed. So for living wills and healthcare powers of attorney, those documents no longer need two witnesses. Now they do still need to be notarized, and a will actually still needs two witnesses as well as being notarized. But the healthcare power of attorney and living will do not need two witnesses. So it makes those documents a little bit easier to get executed in this time of COVID-19. And now managing attorney Angeleigh Dorsey is going to talk to you a little bit about what this means for you and some resources that are available for you.
Thank you, Meredith. Many people put off drafting important documents, taking care of end-of-life planning, things that are on their to-do list, because it's just not pleasant for most people to think about their own death. However, the pandemic has pushed this to the forefront, and it's, as Meredith explained, it's very risky to have multiple people in close proximity to get these documents done. So under this new law, there are several documents that can be prepared and executed in a safe manner under this new legislation. First, the healthcare power of attorney. is a document that allows the person who's making it to designate another trusted person as their agent who can make and communicate important healthcare decisions for them when they are not able to do so. The other document that's impacted by this legislation is the living will. In North Carolina, that's called the Declaration for a Desire for a Natural Death. And that is a document whereby the person who makes it is designating what their end of life wishes are. And these are for end of life situations where the person is very near death. And it sets forth what their wishes are for life prolonging measures to be taken or not taken, according to their preference. Neither of those documents now require witnesses, but they do need to be notarized. And as long as the notary and the principal are in North Carolina and can see each other on some sort of electronic platform like Zoom, they're going to be valid. Additionally, there are these new remote notary and remote video witnesses rules can also apply to things like wills. So while you still need 2 witnesses and a notary to formalize your will, those witnesses, just like the notary, can participate in your will signing via video meetings now. Now, this law is not forever. Most of the provisions only are until August 1st. The living will and the healthcare power of attorney, the no witness requirement with that also ends August 4th or whenever the emergency declaration is lifted in North Carolina. You can get more information about this, including forms for the healthcare power of attorney and the living will, at the North Carolina Secretary of State's website at sosnc.gov. If you're a low-income person, you can get more information or assistance with any of these documents by contacting Legal Aid Senior Helpline at 877-579-7562 or our main Legal Aid Helpline, 866-219-5262. And if you're not low income and you need an attorney to help you with this, you can also contact the North Carolina Bar Association Lawyer Referral Service at ncbar.org.
Thanks, Meredith and Angeleigh. Now we'll turn it over to Jack Lloyd, the supervising attorney of our Economic Justice Initiative.
Oh, good morning. Thank you very much. Yes, I am a supervising attorney with that team, and this morning I'm going to be talking to you very briefly about stimulus checks and how to protect the money in the stimulus checks. We've had a series of questions here at Legal Aid from clients over the last week and a half or so, and so we thought we would just give a very basic primer today on issues related to the stimulus check, and then next week there'll be a longer presentation and more information available. But very basically, so what are the stimulus checks? How much should we expect the stimulus checks to be? How do they get to us? Is our money safe in our bank account? What can we do to protect our money? Those are some basic questions we're going to be talking about today briefly. So first, what is the stimulus check? How much is it? How's it getting to us? So the Coronavirus Aid Relief and Economic Securities Act authorizes payments of $1,200 to individuals, $2,400 for couples, and an additional $500 for children under 17 years old. These payments are only available to individuals making less than $99,000 and couples making less than $198,000. An eligible family of 4, for example, with children under 17 should expect to receive a stimulus check in the amount of approximately $3,400. Social Security and SSI recipients who do not file taxes are slated to receive approximately $1,200. The IRS at this time, it's unclear whether or not people who are receiving the Social Security or the SSI will be able to submit dependent information. That is, information regarding independence, any dependents that you have. That is unclear at this time. Still, they're working it out. But as with many things that I should say, although many of the stimulus checks that were going out electronically have already gone out, Many people have not received their paper checks yet, and there are still lingering questions. This is a fluid situation, as everything related to coronavirus is. Things are changing slightly, being nuanced over time, and that is one of them, whether or not dependents of SSI recipients can claim that deduction. Okay, so how is the money coming to people? Well, as I said, it's either electronically directly deposited into an account from the Treasury Department, or the Treasury Department sends a literal physical check. This started on April 15th. Some individuals began receiving electronic disbursements in their accounts if they had filed tax returns in 2018 and 2019. The Treasury Department was able to use the information from those tax returns. Social Security recipients, SSI recipients, railroad retirees who do not and are not required to file taxes receive the stimulus payments the same way that they received their benefits. So if you did file taxes in 2018 and 2019, the Treasury Department would use that information to electronically deposit the money into that account, your account. If you are a recipient of Social Security, SSI, or railroad retiree and are not required to file, as I said, they're going to use the same accounts that you receive those payments in. I want to give you two website numbers that are very helpful, and they're very easy. IRS.gov, IRS.gov. When you go to the IRS website, you can go to the search bar and type in coronavirus, and you will find that there's a lot of very user-friendly information that can answer questions such as, where is my stimulus check? I haven't gotten my stimulus check. How do I get stimulus checks if I didn't file taxes? I saw a little thing here on the Legal Aid Facebook, but I have more questions about that. And at the IRS website, you will find that you can go to the search bar, coronavirus, and once you get into the coronavirus section and the stimulus check section, they have it broken down into questions so that it's, as I said, it's pretty user-friendly. Another user-friendly website is something called the National Consumer Law Center, and that's just simply NCLC, National Consumer Law Center, nclc.org. So irs.gov and nclc.org. Same thing at the NCLC website. You search, they have the coronavirus section, and it's broken up into questions. There are sections that are clearly written for attorneys, but there are also sections that are presented in a way that are user-friendly for non-attorneys as well. So I highly recommend those two websites for you. Okay, so is our money safe when it goes to these accounts? When it gets to these accounts, is the money safe? And the answer is sometimes, unfortunately. I want to talk for a minute about a couple of the principal potential risks that people have with when they receive their stimulus check. When you receive your stimulus check and it goes into a bank account, I want to talk first about judgment creditors. Judgment creditors. These are parties that have obtained a judgment against you for a certain amount of money. Often there are debt collectors. There are debt collector lawsuits that you may have been a part of, and people obtain judgments, and they may have not obtained the money from those judgments yet. Sometimes people, when a judgment from a debt collector, when a judgment comes against the person, they don't have the money at that time for the debt collector to obtain what the court ordered the person pay. That judgment may be good for a 10-year period of time. And during that period of time, those debt collectors are looking and waiting for the party to maybe get the assets that they need to satisfy the judgment obtained against you. So if you were sued by a debt collector and they obtained a judgment against you, and they were not able to collect that full judgment at the time, this may be an opportunity for them to get that judgment. And they can get that money where? From your stimulus check. Where? In your bank account. That's right. So what happens when a when a party gets a judgment, a debt collector gets a judgment against you, what happens is they are able to issue documents to you that ask you to make certain exemptions. This can be very complicated, and if you do have a judgment against you and you're worried about your stimulus money, we do recommend you seek an attorney. But what we're telling you is what they're able to do is they are able to seek from you a set of exemptions that allow you to protect certain things. One of the things that's not going to be protected for most people is their stimulus money. So I'll give you another example. Your bank, your own bank. What if you have outstanding fees? What if you have an overdrawn account? What if you owe the bank for other loans? Is your own bank able to seize the stimulus check that's in your bank account? Answer is yes, yes. So whether you have a judgment creditor, a judgment hanging out there against you, or you owe money to your bank, the money that you have received in the stimulus check is exposed to those different parties. Now, a lot of people don't know for certain whether or not they've paid off certain loans or paid off certain debts. Sometimes records aren't kept very well. Sometimes the entities to whom we've paid back have not given us the proper receipts. And so there are a series of questions, and I took this directly from that NCLC website. It's an excellent, as I said, an excellent website. And they have a series of questions that they say, you need to ask yourself, okay, I'm going to receive a stimulus check. The stimulus check is going into this bank account. Can someone get that money? Can a judgment creditor get that money? Can my bank get that money? So what NCLC recommends is you ask yourself, has your bank account ever been garnished before? Sometimes consumers give notice of garnishment, and sometimes they do not. Do you know whether or not a judgment has been found against you? Have you ever lost a lawsuit in court? Have you ever lost a lawsuit in court? If you have lost a lawsuit in court and a judgment was levied against you, have you paid it off? Completely paid it off? Because if you have not, that judgment may still be around, and those debt collectors may still be able to obtain what you still owe on that judgment by seizing your stimulus check. Have you ever been served with legal papers related to a lawsuit that you might not have responded to? Unfortunately, we here at Legal Aid have questions frequently from people who over time say, yeah, I remember there was a creditor, maybe a child's medical bills, maybe something else. I remember there was a creditor. I didn't have the money at the time, and so I didn't follow through with that. Well, that party may have obtained a judgment against you that you don't even know about. And they may not have collected on it because they've done an asset check. And at the time that they did the asset check, you didn't have the money available to satisfy the judgment. Now you might. So ask yourself, do you ever remember being served with legal papers? Do you remember losing in court? Do you remember any judgment against you? Has your bank account ever been garnished before? If any of those things has happened, you need to know that the money from the stimulus check in your bank account could be exposed to those parties. There are a couple things you can do here. You can call the bank that's holding this deposit and ask them and talk to them. Have I paid everything that I owe on that back payment, on that loan, whatever it is, financial interaction you've had with the bank? You can get a credit report from a credit reporting agency. You can attempt to determine whether or not a judgment has been satisfied against you through local court records. Unfortunately, what you need to know is that for most people, There's no immediate answer for dealing with these things that ensures that you protect, that your money is protected, okay? And that's what's important to know. The money that has come, the $3,400 saved, as we did in the hypothetical there of a family of four, is sitting in a bank account. For you to go to begin the process of determining what you need to do legally to protect that money could be a long process, and you need to know that. Why do you need to know that? Because sometimes the easiest way to deal with this is to get that money out of that account, ATMs currently, a lot of banks have lifted the restriction for how much money you can withdraw. Sometimes it's been capped at $300, $350, but they have opened that up. Some banks have, your bank may have, and there are other ways to just get that money out of the account. This is the $3,400 that if you know that there might be judgment creditors hanging around looking or waiting for you to have money, maybe the smartest thing to do, the quickest thing to do, is just to get that money out of there. You may have other questions. What about an ex-spouse? What about an ex-spouse, someone you just recently divorced? Do they have access to that bank account? Did you use a tax preparer, and without your own bank account, could the stimulus money have gone to that tax preparer rather than to a bank account? What we recommend that you do is take time to really think through what potential exposure you have out there. Judgment creditors, from your bank, from other parties like an ex-spouse or a tax preparer, and we recommend that you do everything you can to think through what could potentially be exposed. Talking to an attorney is something attorneys always recommend, and I recommend that. Talk to an attorney if you have any questions about this. But unfortunately, this can happen sometimes very quickly, and sometimes the easiest thing to do is just to get your money out of harm's way. As I said, this is a very quick overview of what we're talking about. If you have any questions, I believe that the questions you will be allowed to submit questions later in the day, and we will hopefully be able to find a way to respond to those. There's supposed to be another legal aid presentation related to stimulus checks coming up next week, where we will be providing more information. And at that time, I do not have anything else.
Thanks, Jack. And we will hopefully come to you live. And if not, we'll do a recording again, but we'll hopefully be live on our Facebook page. That's Legal Aid NC next week at 11.